Welcome, everyone. My name is Christopher Hollingsworth, and I'm here for another episode of a Motion Mentors podcast with a very special guest, Matthew Becker from gymlawyers.com. Now, before I let Matthew introduce himself, I just want to say that gymlawyers.com is a virtual law firm that is dedicated to educating gym owners on common legal problems. And their knowledge is meant really to empower business owners to make good decisions. So with that being said, welcome to the call, Matthew.
Hey, Christopher. Thanks for having me. It's a real pleasure. Just as we get started in here, I do have to throw the caveat in of anything we talk about, you can't take it as legal advice. I'm going to give a lot of specific examples. I'm going to talk about a lot of things beyond the traditional attorney. It depends. But please know that every listener situation is different. And if you have something that sounds like something that we're talking about, please reach out and don't just assume that what I'm going to say is directly going to apply to your situation. But other than that, Let's get it on, because I can talk about this stuff all day.
Yeah. And thanks for the disclaimer too, because, a lot of the people that tune into this podcast in particular, they are gym owners, they're business owners, they're entrepreneurs, possibly people even looking to get into this field. And so, yeah, you heard it from him. Don't take it as legal advice. But if you do want legal advice, definitely reach out to Matthew at gymlawyers.com. So, this call is going to be great. I have some really fantastic questions that have been brought to me from the community, things that people are dealing with that they're concerned about legally, that hopefully we can put some information into our gym owners' hands and our entrepreneurs' hands so they can make some educated decisions here. But before we get into that, I'm just curious, Matthew, I'd love for you to share with us how you began your career in law, and also just what led you to your specialization with gyms in general. That's such a niche.
Yeah, to being a gym lawyer, huh? So, all right. So, let's see, it's 2024, right? So back in 2009, I passed the bar in Pennsylvania and started litigating in Pittsburgh, Pennsylvania. Did that for a couple of years and then opened up a CrossFit gym also in Pittsburgh. Did both of those. I was a litigator during the day and I was a gym owner at first thing in the morning and after work at night. For about 6 years. It was right before COVID, I decided I don't like litigating, and being a gym owner is a far more enjoyable profession. So I started closing my legal practice. COVID accelerated that beautifully for me, and came out of COVID as just a gym owner. And I was like, heck yeah. I only have one business that I have to worry about. I'm waking up in the morning, I'm going and I'm running my gym and everything else. I did that for a year. And then Chris Cooper, who is somebody you're very familiar with, he owns Two Brain Business, which is the leading gym consulting company for CrossFit gyms and micro gyms and non-parkour gyms. He and I were having a conversation, and he basically said, we identified that there's a gap in the professional services for gym owners directed toward legal consulting. You have all the business mentorships out there for the different types of gym businesses. You have insurance companies directed toward businesses. You have accounting, financials, loans, all these specialty companies, but nothing was out there helping with gyms with legal consulting. So on a whim, I said, fine, I'm bored just doing one thing, so I'll try another. And we launched Gym Lawyers, and it's just been out there ever since. We're a little bit over 2.5 years. Actually, we're right at 2.5 years right now.
Oh, that is awesome. Thank you so much for sharing that. And what a unique journey and perspective too. And I got to say, it helps a lot that you have been in the gym owner's shoes. Because, I was looking at your website, and one of the things that it says that you're really passionate about is that you want to move these gym owners from a place of fear and you want to have them make educated decisions and decisions where they're really determining what's best for their business, and they're not operating out of like what could happen, so I think that's really fantastic that you started as a gym owner, so you have a lot to say about that.
Oh yeah. Still a gym owner, actually. Still got my gym in Pittsburgh.
Heck yeah.
I just don't do it anymore because my business consulting company was good and they worked me right out of my gym. So
yeah. And for us at Motion Mentors, a lot of the people that we work with, they're trying to get to a place where you are.
Yes.
Where they're just doing what they want to do. Right.
And I will plug and say mentorship was the only way that I got here. And that's not, we don't need to go cha-ching on that or anything. That's a shameless plug for, I owe everything as to where I am today, with a successful gym and a successful second business and, all to mentorship. I would have never gotten here without it. So very key what you guys are doing.
Yeah, thanks for saying that. And yeah, we agree with that as well, obviously, 100%. So let's jump into some of these questions here that I think will really make a big difference for any parkour gym owner, entrepreneur, or a person that's interested in starting their business in that way. So the first one is around risk management for outdoor events. This is a really common scenario that we'll come across. Let's imagine one where a parkour gym owner is planning to host a large free outdoor event in an urban space. Maybe it's like a public park or it's even a college campus. They anticipate a large turnout, let's say like 20 or more people. And they also want to use this event as an opportunity to promote their gym, their classes, their services. What would you say are some of the first steps they should take from a legal standpoint to manage the risks associated with such an event? Or even what are some of the risks that they may not be aware of?
Yeah. Okay. So is this more of just like an exhibition where I'm just going to go up and me and my other gym members who I know currently have the abilities to do this are just going to put on an exhibition of like, here's what cool things my gym can teach you to do? Or is this more of we're going to set up all of this stuff and then we're going to try to get participants from the audience to come and like, I'll teach them a few parkour things and then let them run around a little bit. So like in your scenario, and I can answer both, but are you thinking more of like an exhibition or are you thinking more like we're trying to get participants to come in?
Yeah, this would be more like an exhibition. Like, let's say there's a gym that's already established. They already have customers that are coming in and they want to host an outdoor event with the customers that also come to their gym. And so you have these kids that maybe they're protected under the waiver and the insurance that are in their gym, but now the same gym is hosting this event in a public place. And so they're not bringing equipment from the gym necessarily. They're just using, picnic bench tables, trees in the park, stuff like that.
Yeah. And it's just an exhibition of like their members doing this stuff. Okay.
Yeah.
All right. So first and foremost, we need to make sure that the insurance policy is going to cover them when they leave the four walls of their facility. And I understand this what I do is sort of with insurance, but not insurance. I'm not an insurance agency. I don't provide insurance policies. I work very closely with a company called AGuard, who is like the leading insurance provider for gyms. But they do the policies. I just understand sort of what's in them. And so the first question is, does your policy contain what's called a designated premises exception? We have the four walls of my facility, right? I've rented this space. I'm inside. I get an insurance policy and the insurance policy covers the space. Great. So, but what happens once I leave space? Does the insurance policy extend outside the space? And a lot of times the discussions that we have to have with gym owners is like, it's great that you got this cheap insurance policy, this cheap commercial policy, but understand like this cheap commercial policy is not designed to cover a gym and what you guys are doing. It's designed to cover like the bookstore, okay, or the restaurant, okay, where people are basically just like walking around and sitting there. They're not exposing themselves to an inherently dangerous environment. And so that policy is going to limit and stop as soon as you reach the front door. And so that's sort of like the first line of defense here that we have to understand from the parkour owner who wants to take their people outside. We see, my background is primarily in CrossFit, and that's where gym lawyers got started. So we started with CrossFit, personal training, functional fitness, and we're expanding out from that. And so we see that in our original industry a lot when they like go outside to run around the block. And I'd imagine, parkour gyms are doing that as well. They send people out there, hey, let's go get our cardio on a little bit. Let's run around the block or run around the building and come back in. But it becomes even more important when we leave that gym and we go to the park. Is the insurance policy even going to cover it? So that's question number one.
So that's called a designated premises extension?
Exception, a designated premise exception, right? So that you have your premises, you have a coverage outside.
Yeah, that makes sense. Now, would that extend just out towards the, like, let's say we want to host like a water balloon fight in our parking lot, does that typically just extend outside the building, or does it usually also include things like public spaces?
It will include public spaces. I can't give a guarantee on that because every insurance company is going to look for every reason to have a denial of coverage. But for the most part, as long as you're carrying on the activities that you're already covered to carry and you're just carrying them on somewhere else, like in a park, you should be covered as long as you have that in the policy. And these are all great questions that listeners should be writing down if they have questions about their policy, to go back to their insurance company and ask get real specific with your insurance company so they know exactly what you're doing.
Perfect. Thank you so much, Matthew. Let's rewind a bit back to the other scenario, and let's imagine that we have a parkour gym that's been invited to an event like such as like a farmer's market or a fair that's happening, and they want to bring out their equipment, maybe some vault boxes, some rail trainers, some panel mats, have a few coaches, and they're actively now inviting people who have not signed a waiver, people who have never participated in their gym before, to come participate on their equipment and practice things. What would you say are the first steps that group of people should take to manage risks for that event?
So it's very similar, and we can kind of, what I'm going to say here will apply also to the previous answer as well. But again, first we got to check the insurance policy, but let's check that box and let's assume the insurance policy is covering. Next, we need to make sure that our waiver covers what it is that we're trying to do. And that's going to come kind of in three different places here. One is we need to make sure the waiver is robust to begin with. So again, are we putting people on notice in what's called the acknowledgement of danger portion of your liability waiver? Are they acknowledging that some dangers that they're going to be exposed to could include things that they're going to encounter outside? Okay. So that's sort of like question number one. And then from there with the waiver, has everybody who is participating from the gym signed this waiver? Okay. So staff needs to have signed it. Your other members, the first time we were just talking about the exhibition, they need to make, all of those people need to make sure that they've signed it. But now we're at a farmer's market and we're putting on like hey, come check us out and test this thing out. Yes, you need to have some sort of a way to have somebody acknowledge the danger that they're about to partake in. And, there can be some weighing of the amount of exposure here. Okay, like if you just set up a foam box and you have people do like a two-handed jump over a foam box, is there really a big danger there? Sure, there's a danger, but in weighing the cost of having somebody sign a waiver at a farmer's market versus the ability or the chance you're going to get sued because they're just jumping over a box, that's for you to weigh out. But as soon as we have people swinging from things, we have people, manipulating around a lot of equipment, especially equipment that we're bringing with us. that all just, the more equipment we bring and the more we have people doing things, the more we're expanding our potential for liability. And at some point, you really need to have people sign a waiver who are going to be participating with you.
Yeah, that makes total sense. And I can hear like just the level of risk that is taken also kind of necessitates the level of kind of making people knowing the risks that are involved. So I can hear that. Like sometimes you have signs that are up that say like, hey, attempt this at your own risk. And if you have hundreds of people coming through and all you have is a foam block and a rail trainer, the chances of someone getting hurt on that are very small, But if you have like a bar cage that's set up, like you said, where people are swinging and jumping and, there's like a lot of high explosive movement. A guy that's 2 or 3 beers in sees it and he's like, I want to try that, like now you've got a problem. Yeah.
That's me. It's like, whoa, I can do a muscle up on that. Okay, hold my beer.
Yeah, no,
I'll get up there.
But you signed the waiver,
Yeah, right.
So, oh, that's so good. So this is perfect. Segueing into my next question here. Let's say you have a super robust waiver. And I've come across this actually in my time as a gym consultant. I've come across people that think a robust waiver that covers like everything that could possibly happen entirely protects against all liabilities during parkour classes, and they no longer need insurance because they've signed this waiver. So I would love for you to share with us, why is relying on just waivers insufficient? What even is that about?
Oh boy. I will say in 2.5 years, I've never had anybody say I got rid of my insurance. So let's just kind of have that as a blanket statement here. If you are running a business, if you're running a gym, you need an insurance policy. Do not leave yourself exposed without the insurance policy. Okay. Now layering on top of that, there is no such thing as a bulletproof waiver. And any attorney, any legal person who tells you, oh yeah, but give me $500 and I'll give you a bulletproof anything, run away. Any attorney who gives you a definitive, run away, because the law is so fluid, and that's why traditionally our favorite answer is it depends, because every situation you bring me is going to have a different fact pattern and is going to have a different situation. And so we can't give you a definitive to cover everything. All right. Now, the next problem is the reason that waivers cannot be bulletproof is because there's different types of negligence. And all of this stuff, liability, insurances, waivers, okay, it's all involved in order to cover a gym against what's called negligence. And people are familiar with that term. Your listeners will know what that term is, but that's a legal term that basically means I, as a gym owner, have a duty to protect you coming into my gym. You've come in and you've gotten injured, so I've breached that duty to protect you. The breach is the injury. You broke your arm, you broke your leg, you hurt your back, whatever it is. And now there's some sort of monetary damage that you are going to claim that I owe you. Okay? Like that's negligence in its most first-year law school understanding of negligence. All right. Now, there's primarily two types of negligence. There is gross negligence and there's ordinary negligence. Okay, so let's take a warped wall. Okay, common in a parkour gym, right? And let's say I come into your gym and I run up the warped wall. I grab the top. It's a hot, sweaty day. I slip off the top. I slide down and I hurt myself somehow. Okay, you had a duty to protect me. It's a hot day. Maybe you didn't have any chalk on the floor or something like that. So you've kind of breached that duty. And I hurt myself. There's technically negligence there if it could have been a preventable problem, right? Maybe I said, like, I'm not really feeling too good today. And you're like, well, just go try that warped wall one time and let's see what happens. Okay. So that's ordinary negligence in some part, that's, again, I can't speak definitively on that, but we would have an argument that that's ordinary negligence because it's a potential injury in just in the ordinary course of business. Okay. I walk in and I jump up and I grab a bar. I slip off the bar. I land on my back. Well, crap happens. Okay. As long as the gym owner didn't do anything or didn't not do something in order to prevent that, we have an argument that it's ordinary. Your waiver is going to cover that and your insurance is going to cover that. Okay. Let me flip the script for a second though. So now let's assume I come in and you just had like a class of people who were all over that warped wall. It's a hot day. It's super sweaty. They're jumping up, they're grabbing, they're sliding down, their shirts are off and everything. And turns out that warped wall is now covered in sweat. Okay. It's covered in sweat because as the coach, you just watched all these people slide down the warped wall and get it all sweatied up. But you did nothing to clear off that warped wall before I came in as your private training client and have you run up that warped wall. I go to run up that warped wall the first time. I slip on all of that sweat. I break my ankle. Okay. There's an argument that you knew or should have known that there was a danger that existed on that warped wall and you chose to do nothing in order to fix it. That's the potential for gross negligence.
And gross negligence is where people get in hot water. And the waiver goes out the window. The
waiver is right out the window.
I see.
Yep. You can never waive gross negligence because you have a duty to protect.
Wow. Yeah. Now, that's super important for people to know. I would love to get into the topic of gross negligence more. I'm just curious, have you seen any examples in gyms? And you don't need to provide names by any means, but have you seen examples of gross negligence? Anything that you could point out to anyone listening as like hey, you may not consider this as gross negligence, but it is, and you should watch out for it.
I have yet to see it too much in parkour gyms. Okay. But, where we see it primarily in gyms is when we'll see this really commonly in CrossFit gyms. And I have seen this in parkour gyms. I just don't know how regular it is. We're trying to get a client to do a new type of movement that could be a potentially dangerous movement, a muscle up, okay, or a handstand or again, like running up a warped wall or something like that. And the client pushes back and says, I'm not really comfortable doing that. Okay. I don't really feel like doing that today, or I don't really feel well today, or my back hurts today, or my shoulder's giving me a little bit of an issue today. I don't really want to do it. And what the gym owner does is they go, hey guys, come on over here. Let's get him to do it. Come on. You can get there. Come on, go. And like everybody comes around and starts screaming and yelling. That's a potential for gross negligence.
Wow. That's huge to point out. Oh my gosh.
Be real careful with that stuff because the member has just said, I don't feel safe doing something. The gym owner just disregarded that and said, whatever, you can do it. And they get all the people to come over to do it.
That's so huge because, and this is really important because parkour coaches interact with a multitude of personalities, but one of the most common personality types that parkour coaches interact with is a personality type called an assumed inadequacy, where children or adults will come in and say they already are walking in with they are assuming they're inadequate. I can't do this or I can't do that. And there's a fine line between encouraging someone to confront that limiting belief that they have about themselves and put themselves into a dangerous situation like what you're saying. And so, man, I'm glad you said this because toe that line for sure.
Yeah. And let me be clear. I'm not saying as a coach, don't encourage your people to go beyond their limits. Okay. That's how we develop as athletes is pushing that envelope. What I'm saying is you're right. You got to toe that line. You have to listen to your member. And if the member just says like, I'm a little afraid to do that, that's like one thing. If the member's like, my shoulder's kind of bothering me today, I don't really want to do it, that should be a red flag. That should be like okay, you know what? We're going to back off that today. And we'll come back to that next time.
Absolutely.
So it's a fine line, but we have to listen to the member. We have to read the room. We have to understand that like I'm pushing my member beyond just like I have a fear of getting upside down.
Totally. Okay, so this is a really great just branch off point as well, because we're talking about a gym owner or a parkour business owner that believes that a personal injury waiver is enough to protect against the liabilities during parkour classes, and they don't need insurance. Where I've seen that the most is with a individual parkour coach who has gone out and made their own business, and now they're working with 5, 10 clients personally, and they just have a waiver and they don't necessarily have insurance. I'm curious for you, what specific types of insurance should they consider, or what advice would you have for that particular type of entrepreneur, someone that doesn't necessarily have a space, but they're operating a business practice?
We're getting this is going to go in a different direction, but I want to plant this seed for future conversations. Is one of the first questions I'm going to have for that gym owner or that individual is, what kind of corporate entity do you have set up to protect your personal assets? Okay. I know, Jimmy, your partner, and I have kind of talked about that. I know the two of you have set up your corporate entity for Motion Mentors. And, but that's a common problem that we see. And again, I'm not going to derail this answer. I'll get to the answer, but is a coach is like, I'm particularly skilled, so I'm just going to go start to get my own clientele, and I'm just going to take that client's money directly, and I'm just going to teach them what to do. Great, but if you're doing as what's called a sole proprietorship, you've just exposed all of your money and your bank account and your car and everything else that you own to injuring one of these, half little clients that you have that aren't in some sort of brick and mortar space. Okay.
So you're saying there's now nothing in the way between someone getting hurt in their classes and that basically coming out of their personal assets,
especially if they don't have an insurance policy. Yep. Yep.
That's good to know.
So I could go for another 45 minutes on corporate entity setup, but it wasn't the topic today. So I'll get off that soapbox. But you said insurance. Yeah. Again, there are insurance companies out there. Again, I don't get any kickback from promoting A-Guard. I only get the kickback because I know a gym or a gym owner is covered if they actually have a policy that is designed to cover the activity that they're covering. Okay. But, calling up one of those insurance companies and just saying, this is what I'm doing. I'm doing it in a park. I'm doing it in somebody else's garage. I'm doing it in somebody else's facility. But I'm doing it as like my own business, as I'm sort of like an independent contractor. I'm a sole business owner. I'm an entrepreneur, whatever title you want to give them. There are policies out there, just minimal policies they can get that's going to cover them in the event of, they injure somebody. Anytime you're telling somebody something to do, you've now exposed yourself to the liability that they get injured doing what you told them to do. So, it might cause some research. They might need to reach out to you guys and just say, your job at Motion Mentors is to mentor businesses, big or small. And that's your job. And there are resources out there to anybody listening that you pay somebody for professionally for the services that they're designed to offer. So use the resources, because if you don't know, I guarantee you, if you're trying to spin off of your current gym, you're trying to go do your own thing and you don't know what you don't know, there is somebody who knows what you don't know. And you're listening to this, so you already know somebody, the host of this podcast, who knows a lot of what you don't know. So don't let ignorance be, because ignorance in the law, it's not a defense. Go ask somebody, find a resource that knows what to do.
Yeah, really well said. And they'll catch you on that for sure, because ignorance of the law doesn't excuse you of it for sure. I'm curious as well. Let's go back to a gym owner that wants to expand their classes to offer outside classes. You've already talked about the designated premises exception, making sure that that's inside of your insurance. But for someone that wants to include more outdoor training sessions and events, from a legal perspective, what are some other key considerations that a gym owner should keep in mind as they're structuring those new services?
There's the biggest one that's going to come into mind is mainly going to be whether or not your waiver is designed to acknowledge the danger that they're going to be exposing themselves now to outside. So there's multiple different sections that a proper waiver needs to have. There's a lot of other things we can add to it, but there's various sections that a waiver has to have. The top three are what I call the trio of danger. That's the acknowledgement of danger, the acceptance of responsibility, and the assumption of risk. Okay, so the acknowledgement of danger, where I'm saying I'm walking into a parkour gym and this gym has unique dangers that could result in me getting injured. And so I, in writing, need to acknowledge what those dangers are. And the dangers of a parkour gym are different than the dangers of a cheerleading gym, which are different than the dangers of an MMA gym, which are different than the dangers of a CrossFit gym. So you first have to have an acknowledgement of danger specific to the activity that you're offering, right? And then you need the acceptance of responsibility. So I've acknowledged this. Despite acknowledging all these dangers, I'm accepting the responsibility to continue. And then I'm going to assume the risk. And I'm now assuming on behalf of myself and all my heirs and everybody else that I'm assuming the risk that I'm going to get injured. Okay. So that's the trio of danger. So once we add services, we have to make sure that our acknowledgement of danger covers the services that we're adding. Okay. Easy example of this. If let's say you're in Southern California or Texas or Arizona or Florida, and we're going to throw a bunch of people outside and they're going to go outside for 30 minutes, heat stroke, sunburn, dehydration, heat exhaustion. Okay. Have we had our members acknowledge that that's a potential danger of being at my gym? So that's sort of like, at the top of, insurance covers us going outside. Our waiver is now going to cover the types of activities. And then, the other thing that we have to be careful of with exposure of liability is the expansion of individual services. Not so much in the expansion of activities, okay, but there's, we see this more in parkour gyms again and cheerleading and gymnastics, which is the variation between adult clients and minors. And so the different kinds of services that we're now going to offer may necessitate different types of waivers. Because we personally don't like to see the adult waiver being put in front of a 6-year-old and having mom or dad acknowledge it. It's awkward, right. It's clunky, it's not best practices, even though it's common practices. So these are some of the things. So first we've got insurance is covering us. Great. Do we have the acknowledgement of danger for the activity that we're expanding on? Good. Do we have a waiver itself that covers the type of service that we're now offering?
Yeah, that makes total sense. And I can hear like it would be really important for a gym owner to actually really do the intellectual effort to think of, well, what are the risks that people are assuming when they train outside? What are the locations that I'm bringing them to, that I want to bring them to? And what are some of the things that could happen at that location? For example, I used to work in the Pacific Northwest quite a bit, and it would rain all the time.
All the time.
Yeah, surfaces change dramatically when it rains.
God, yes.
And so there has to be like an acknowledgement, acceptance, and an assumption. Hey, it's not a matter of if, but when you're going to slip and bust your ass in the rain, And so, I can hear why it would be important for a gym owner to really get all of that in writing and factor that out. Thanks for sharing that. Anything else that you want to say on that topic? I got a couple more questions for you.
Let's go on to another question. I think if there's something that we didn't cover there, it's going to come up in the regular questions.
Okay, cool. So this one's a bit more nuanced, and it's in the same conversational field, but let's say you got a gym owner, they're like, I love college campuses. This is a specific example. College campuses are huge for training. They're just really well designed architecturally. They're on Sundays, no one's really there. And so it's like, you can just go train as an athlete. Now, I've also seen businesses attempt to host events at places like colleges. So if you do have an event like that, what is the process you'd say on formally contacting the property owners? Do they even need to? What legal risk does that pose if they don't? How should they approach that situation?
Yeah. So first and foremost, you should never go on somebody else's property and conduct anything related to your business. There's a big trespass issue there. So, trespassing alone, even if it's open to the public, there are issues that, like, being open to the public to somebody to walk through college campus is different than you going on as a business and hosting something that benefits your business on the public space. Okay. That's why if I go to a park and I'm just taking my family and we're having a picnic, I don't even worry about anything. If I'm going to the park and I'm operating a business and I'm doing like a boot camp class outside or a parkour class outside, and all of a sudden I might need a permit, because there's different standards when we're operating a business versus just being there personally. Okay. So, never make the assumption that you can just go on somebody else's property, use their equipment and everything else on behalf of your business without telling somebody. And this is not one of those, what is the old saying? Like, it's better to ask for forgiveness than ask for permission. You're not that situation.
Not in this case. Yeah.
Ask permission first.
Yeah. I see people kind of try to get around this too by saying, well, we're not offering a service. We're just playing with our clients and playing with our
mincing terms. Yeah.
Yeah. And that's very good. Yeah. So that you heard it from Matthew, guys. Stop mincing the terms up there.
That's like people say, we don't have members. We have partners. I'm like, it's a member.
Yeah.
Okay.
Yeah. It sounds like
agreement. Follow
it's semantics, and would it hold up in court if someone got hurt? Probably not.
No.
Yeah.
And because, a big problem that you're exposing yourself to here is you now go on somebody else's property. You're operating something business related on that property, and somebody gets hurt. Well, that person, depending on what they got hurt, how they got hurt, may now have a claim against the property owner for some sort of invitee or trespasser liability. Depends on what state you're in and what happens, et cetera, et cetera. But they may have a claim against that property owner. Well, if you take your parkour business onto that property, you run something, and a promotion, a play, whatever you want to call it, and that person gets hurt and they sue the property owner, you can bet that property owner is coming against you, the gym owner, because you didn't have any right or permission to be there. So you're just exposing yourself to even more liability, because now not only do we have, we have the insurance question, we have the waiver question, we're going out and telling people to do things. So we've exposed ourselves to liability because we're telling people to do things, and we've done it on property where we don't technically have permission. So that property owner is now, we're exposing ourselves to their liability. So, you're just layering and layering and layering on potential exposure to your business.
And this is so good too, because these are things that people don't consider, and it's also in that realm what you were talking about. They don't know it, and they don't even know that they don't know it. They're operating like, well, this is outside of our business, it's separate, and it helps it. It's a win-win. And I want to make absolutely sure to articulate to anybody listening that I'm asking these questions not to discourage anybody, but to ensure that really you're following the proper channels, the legal channels, so that your business doesn't get taken away, and because that has happened in this industry as well. So yeah, thanks for answering that, Matthew. That's great.
Yeah. And I think you make a really good, I just want to make, reemphasize, I think that you make a really good point there, because I think we can be looked at as like Buzz Killingtons a lot of times, if you're ever familiar with like that term from Family Guy, where, you go to the suits and the suits tell you like, no, you can't do that. I don't care if you do it. Okay. I just care if you do it intelligently. Like, come to me and say like you're doing, or, gym owners, we're free to reach out to and talk to, come to me and say like, here's the situation that I have. Let me educate you on the potentials. And if you want to tell me to then just go like blow smoke, that's fine. But at least you then know what you're educated. You don't have any reason to fear this stuff, because you're not afraid of it anymore, because you now understand it. And now you can make an educated decision about what's best for your business.
Yeah, really well said, Matthew. Yeah, and I can hear why you're in this industry. I can hear how you care about it and what you're attempting to equip people with, so they can really make the difference that they're interested in making in their community, while also continuing to protect and build upon their assets. So. Right. Yeah, that's fantastic. Okay, well, my last question here, and I really appreciate your time. Thank you so much for being with us. Is what are some of the common legal misconceptions that you've encountered among gym owners? And this can be in the realm of outdoor events, training sessions, insurance. It's just some of the common things you've encountered, misconceptions, and how you address them. Basically, any advice that you'd leave anyone listening, think they may be dealing with.
Okay, so there's two common paradigms that we have to get over with gym owners. One is, I've done it this way for years, so why do I need to change? And that one for me is sort of like personally frustrating, because the worst thing that you can do in your business is stay static in one way because you've done it this way for years. I think there's an old business adage that like the competitor that hears your employees say, I don't know why we do it this way, this is the way we've done it for years, is a competitor that's now chomping at the bits because they know exactly how much they need to innovate in order to put you out of business. Just because you've done it, just because you've had the same waiver, just because you've used the same insurance, or you've never had a membership agreement for the past 5 years of your business, doesn't mean it's not time to get that stuff put in place. It just means the bomb hasn't gone off yet. The second, I said there's two. The second one is, I haven't had a problem with this yet, so I don't know why I need to make it a big deal. And that's another one that's then just an educational opportunity for us. And I get it. Like, this stuff isn't sexy, like, it's not like, oh, great, I can go spend money on a new liability waiver. I can go spend money on a new operating agreement. Great. The problem is it's incredibly important and necessary. I remember years ago complaining to my wife that I had to like buy a furnace. And I was like, what's the least sexy thing I can put in my house? Right? Like, is a big tube in my basement that is the furnace that I'm not even gonna like sit in the basement and watch or whatever, right? Like, I think it was like $2,500 or something like that. I was like, what a terrible weight, but it's necessary, because when I lived in Pittsburgh, it gets 11 degrees in the winter and we need heat. So no, it's not a sexy thing to buy, but it's a necessary thing to buy. So those are the two kind of common misconceptions that we hear, that we just have to then step back and sort of educate the gym owner. I'm like, I get it. I'm a gym owner. I understand margins are tight, and I'd much rather buy a new barbell than something legal. But in the end, it's necessary. And if you wait until it is a problem, it's too late.
Yeah. Oh, so well said. Thank you for the advice. And there's definitely been some situations that I know of personally where a gym has completely gone under because of the latter of what you said, stepping over things that, it hasn't been an issue yet. So why would it be in the future? And then the whole place gets shut down because, the building isn't up to code, or they needed to replace their pipes, or there was a fire issue, So super, super well said. And Matthew, thank you so much for your time. Thank you for joining us on this podcast.
Anytime, guys. Anytime.
And anyone listening, you can reach out to Matthew for a free consultation on his website, which is gymlawyers.com. And, Jimmy Davidson and myself, we're really in the business of like building parkour businesses. But Matthew's in the business of supporting you and protecting what you are building. And so reach out to him. He'll hear about your business. He'll identify any potential legal exposures that you have, review the paperwork that you've got, educate you on any applicable laws. So he's in your corner. He's got your back. And I really appreciate you being here and just sharing so generously all of your advice and information that you've collected, Matthew. Thank you.
Yeah, you're welcome, Christopher. It's my pleasure. I live and breathe this stuff. Like I get up in the morning and just live and breathe this stuff all day long. So it's just a pleasure for me to be able to talk about it, and happy to come back and talk about it more. You can give me more scenarios.
Oh yeah. If anyone has any questions they'd like to ask Matthew, you're welcome to leave them in the comments here on the YouTube video. You can reach out to me on Instagram and send me a message, and I will personally reach out to Matthew, and we'll get another podcast going and get your questions answered. So he just agreed to do that right here on this call, so we'll get that going. But yeah, thank you for your time, Matthew. We're going to cut it here, and
You're welcome.
Have a great rest of your day. Anyone that's listening.